Good evening. Tonight we'll be discussing Bates chapters 19 and 20 and also covering England chapter 7. I'll start with my commentary, Bates chapter 19, which deals with civil enforcement remedies for citizens. And this is from page 839 onwards. 19.1 talks about some of the issues in relation to family or in environmental law which are particularly relevant and where citizens can become involved, and they may do so by seeking civil remedies. Well, nothing new about that. By prosecuting offenders, that is very novel. By contesting the legality of a decision, which is judicial review, and by appealing the merits of a decision, which is merits review. So if someone is aggrieved in environmental law, they have these four disparate remedies that they can pursue. So number one, they can sue, a civil remedy, which is nothing new. Second is they can actually prosecute, and that is very new. In criminal law, there is always the opportunity for citizens' arrests, and there is the opportunity for private prosecutions, but these things are rarely exercised. In environmental law, it's much more obvious and, in a sense, encouraged to a degree. Now, if a judicial officer makes a decision which is to be contested, that's done by judicial review, and there's a lot of material in chapter 20 on that. And if an administrative decision is made and that's to be challenged, that can be done by way of merits review. So all of these things can involve individuals. Civil enforcement, I won't speak about that much, that's on page 840, and one of the remedies available is an injunction where there's a request for an order to stop the proceedings that have been made. If we proceed further, you'll see that there are commentaries in relation to other matters which might be relevant for the material. Thanks, Lynn. We'll see you tomorrow. There is the matter of costs in civil litigation, which is 19.23 onwards, and there's some discussion about public interest litigation. So I'm glossing over that fairly quickly, but by all means, read that for yourself. At 19.32, there's commentary in relation to the decision of Snowy River Alliance against Water Administration Ministerial Corporation, and in that case, the successful respondent claimed costs, which was relevant in that particular case. So there's a neat summary at 19.34 in relation to the sorts of questions that might be considered by a court in determining the question of costs. Now, when it comes to seeking a remedy by a citizen for environmental litigation, costs is always critically important. And arguably, it's one of the greatest impediments to enforcement through civil proceedings of an individual litigant. Fortunately, however, courts very often do not exercise their discretion against litigants who are individuals, but they can do so. There's some reference there to indemnity costs, and indemnity costs mean all the costs. I'll just explain. In legal proceedings, there's a difference between party and party costs and solicitor and own client costs. The amount that a solicitor charges to a client is more, generally speaking, than the prescribed fee on the scale of fees for courts. Courts have a scale, and they say an appropriate fee for a solicitor to institute proceedings might be this much, but the amount that the solicitor actually charges is very often considerably more than that. So we have a difference between party and party costs, which are awarded if one party loses, and it's generally as per the scale. But sometimes, if the litigation is very poorly conceived or very poorly conducted, the courts may order indemnity costs, meaning whatever was paid needs to be reimbursed and not just the court scale. I'll move on to now chapter 20, which deals with challenging environmental decision making. And 20.1 deals with a number of issues, but particularly merits appeals and then later judicial review. Merits appeals are administrative appeals in circumstances where the decision made administratively is to be challenged. And where it's a merits appeal, the court or tribunal hearing the matter will hear the matter afresh and step into the shoes, as it were, of the administrative decision maker. So the decision maker on a merits appeal rehears the matter, and not just necessarily the matters that were before the original decision maker, but anything else that might be deemed relevant. So decision makers on a merits appeal make the decision afresh. There are normally no costs ramifications in relation to a merits appeal. At 20.11, Bates deals with evidence and expert witnesses on environmental cases, and there's reference to alternate dispute resolution in environmental law, and that's at paragraph 20.13. Now, very interesting topic is judicial review, and the commentary is from 20.17 pretty much through to the end of the chapter and the end of the book. So 20.17, judicial review is a form of civil enforcement, and it's directed at administrative decision making. At 20.18, the judiciary must be careful about trespassing onto the merits of administrative decisions in the guise of judicial review. Judicial review is really this: where there is a challenge against a decision that has been made, it can be considered by the courts under judicial review, where the court is not asked, as in a merits appeal, to rehear the matter, but the court is asked to determine whether the administrative decision that was made at first instance was wrong for any one of a number of reasons. And in that regard, I'll refer you to 20.20, where there are a number of grounds about the decisions that may be challenged under judicial review pursuant to the Commonwealth legislation, which is the Administrative Decisions Judicial Review Act 1977. So Bates makes this comment: broadly speaking, the courts have determined that the standard expected of an administrative decision is that before the decision is made, the persons empowered to make the decision must take into account all relevant information, excluded irrelevant matters, and reached a conclusion that, on the weight of evidence, is reasonable in the circumstances. So if a merits review is not sought, and there's a challenge to the way in which the decision was made, or the basis upon which that decision was made, then the appropriate action is judicial review. Now, at Section 5 of the Act, it lays out a number of grounds of review. The first is that there was a breach of the rules of natural justice in connection with the making of the decision. Natural justice, which we'll come to shortly, really means the rules associated with appropriate and procedural fairness. For example, if someone is not given an opportunity to be heard on the matter, and they are an appropriate person to make a submission, then the court or tribunal breaches its basic obligation to provide that individual with natural justice. Bates, referring to Section 5 of the Commonwealth Act, goes on to make reference to other grounds for judicial review: that procedures that were required to be observed by law were not observed, that persons who purported to make decisions did not have jurisdiction to make the decision. So that's clearly a basis for asking for the order or the decision to be made to be overturned. So if someone associated with mining department purports to make a decision which relates to, let's say, fisheries, an application to judicial review can be made to say that this person did not have the jurisdiction to make the decision. Otherwise, grounds for judicial review: the making of a decision was an improper exercise of the power, that the decision involved an error of law. In other words, the decision was made based on a certain understanding of the legal principle, but they got it wrong. That law was incorrectly applied. That the decision was induced or affected by fraud, that there was no evidence or other material to justify the decision, and the decision was contrary to law. Other grounds: that irrelevant considerations were taken into account, or the decision maker failed to take into account relevant decisions. we see this a lot in criminal law appeals, where one of the bases of the appeals is that in coming to a decision, a judge failed to take into account relevant matters, but conversely took into account irrelevant matters. So these are all bases upon which arguments can be laid to challenge an administrative decision by way of judicial review, or that the power which was exercised in a discretionary manner was exercised in bad faith, or no reasonable person could have possibly exercised the power in the way in which the administrator did so. So, since judicial review seeks to challenge the decision-making process, it is vitally dependent on evidence as to how the decision was made. Failure to supply reasons itself can be a basis for challenging the decision. And there's commentary about, in the case of Sydney Harrison against City of Tea Tree Gully, 2001, where it was held that if reasons for a decision were not known, then the decision can still be set aside for being legally unreasonable. If the reasons were known, then they can be challenged for failure to take into account reasonable considerations. So there are some things which have been set up by governments to try to resist, minimise or stop applications for judicial review. You'll appreciate, of course, that most applications for judicial review occur in circumstances where a government official, a bureaucrat, has come to an administrative decision, and that's being challenged on the basis that for any one of those reasons in judicial review, the decision should never have been made, or if it had been made, it should never have been made the way it has been. So governments, in an attempt to stop a multitude of applications being made, have attempted to set up barriers, and we do that, and that's been done by privative clauses. So Bates at 20.25 says, frustrated by judicial review of government decisions through Parliament, governments may attempt to oust or at least limit the court's ability to review government decision making. And these statutory provisions to seek or limit judicial review are known as privative clauses. And there's a decision there of Kirk and the Industrial Court, 2010 High Court decision, which expanded on the earlier decision of Kirk. 20.30, Bates talks about the rules of natural justice, or procedural fairness, as they're often known. And a person who is subject to a decision should have an opportunity to state their case or make submissions. And if not, they are said to have been deprived of their rights to natural justice and procedural fairness. Now, I will, to a degree, gloss over that and move to quickly identify other issues that may become the basis for judicial review applications. At 20.42, there's a commentary in relation to procedural irregularities. At 20.44, a want or excess of power. A want of power meaning the person making the decision had no power to make that decision, or did have some power but went well in excess of the power conferred upon him or her. So therefore we say there was a want or excess of power. And I'll leave you to read through the rest of that chapter for yourself. There's commentary in relation to the question of taking into account irrelevant considerations or failing to take into account relevant decisions. And in that regard, there's the reference to the 1986 High Court decision of Minister for Aboriginal Affairs against Pico Wallsend Limited, which you might want to consider as part of that commentary. There is an obligation to, in some instances, have regard to or consider, and we've talked about that in terms of the context of ecologically sustainable development and some of the issues concerning that. So at 20.61, Bates makes reference to that commentary. Then there's the question of whether the decision maker had improper purposes or ulterior motives, and that of course can be the basis for rejection or a basis for a claim for judicial review. That's at 20.68, and then manifest unreasonableness at 20.69 through to the end of that chapter. All right, so that is a very brief overview of the principles associated with judicial review, an idea of when the application can be made, how the application is made, and on what basis the application can be brought before the court. That completes my commentary on Bates. I'd like to move on and just make some comments in relation to England, Chapter 7, dealing with disputes, appeals, and enforcement. But before I do, I'll just check if there's any questions. No, nothing online. All right. In England, it's pages 220 to 243, and I'll move through this fairly quickly. International law identifies three fundamental access rights. Firstly, there's a right to access information, public participation in decision-making, and access to justice. The Sustainable Planning Act does make reference to some of those rights, and helpfully, England has produced a table at 7.1 on page 221. England then refers to the resolution bodies available for issues to do with the Sustainable Planning Act, the Planning and Environment Court, of course, and alternatively the Building and Development Dispute Resolution Committee. The Sustainable Planning Act creates a number of development offences when they can be failing to request compliance assessment, or carrying out assessment development without a permit, or contravening a development permit. So now we're talking about offences and enforcement provisions. Offence provisions are usually brought in the Magistrates' Court, and as we mentioned before, any person can bring that prosecution, and that's section 597 of the Sustainable Planning Act. The Magistrates' Court may make orders against a defendant if it considers appropriate, including imposing a penalty. Legal proceedings for a development offence must be commenced within 1 year of the commission or within 6 months of becoming aware of it. The Planning and Environment Court is able to make enforcement orders, that is, to remedy or restrain the commission of offences, and that can be done by way of declaration, and the Sustainable Planning Act allows for any person to ask the Planning and Environment Court for a declaration about a matter done or to be done, or that should have been done in respect of the Sustainable Planning Act. A declaration is a statement by a court as to what the position of the law is. It's, if you like, an adjudication in response to a question that's posed to it by a litigant. Instead of applying to the Planning and Environment Court, there is the alternative of going to the BDC as the relevant alternate dispute resolution body. And that, of course, offers a less formal alternative to the Planning and Environment Court. So you would consider going to the Building and Development Dispute Resolution Committee in certain circumstances. All right, now that body has been set up through the Planning and Environment Court. I believe Peter Stilgo, senior member at QCAT, was instrumental in doing that during her time at the Planning and Environment Court. Now, if you were involved in litigation in the Planning and Environment Court, there are two sets of rules that you'd want to consider. The first is that the Planning and Environment Court has its own rules of procedure, and these are relatively straightforward, but they're complemented by the Uniform Civil Procedure Rules, which are vastly more complex. And you'd look to the specific rules of the court, the Planning and Environment Court, first, and only have recourse to the Uniform Civil Procedure Rules if there is a gap. Now, when we talk about these rules, these court rules, we're really talking about a set of guidelines that apply to the way in which litigation is conducted. For example, there'll be rules that apply for PD. So for PD1, which is the rules relating to Practice Direction 1 for the Planning and Environment Court, it will give guidance to litigants in relation to the conduct of proceedings, and it's a 4-page document. It's easily read and understood, and what it does is identify, if you like, the process that needs to be followed by a litigant. So if you are involved as a litigant in the Planning and Environment Court jurisdiction, the first thing you need to do is look at Practice Direction number 1 of 2010 to get an idea of how to go about conducting your litigation. In the Planning and Environment Court, there is much more emphasis on cases through case management than is the case in other courts. So case management is where the judges roll up their sleeves, so to speak, and actually actively get involved in the running of the conduct of the case by ensuring that certain steps are followed, that it's done quickly and promptly, that it's not left wandering along, waiting for years and years of time to elapse. So there are some pre-trial management techniques that the courts use in that regard, giving or making orders requiring courts disclose documents even to the judge at an early stage, limiting the duration of the hearing, requiring experts in the same field give evidence consecutively, concurrently, or in some other way, or any other order that it believes is necessary to ensure that the matter proceeds expeditiously. In relation to expert evidence, there's always been the concern that the person who pays the expert is looking for a favourable response. And in response to criticism about that, one of the ways that the courts can deal with it is to ask for expert evidence to give their evidence consecutively or even concurrently, or have an enclave where the experts try to thrash out a meeting through a joint meeting of the experts. And that way, very often the experts are able to agree on, let's say, 9 of 10 issues, but disagree on one final issue, which means that the proceedings are much quicker, with an argument of only 1 out of 10 issues rather than having to go through each one of the 10 issues themselves. The ADR process, the Alternative Dispute Resolution process, has now been widely adopted in the planning and in court jurisdiction, and of course there is the Building and Development Dispute Resolution Committees, which is available, generally speaking, for less difficult and more procedural matters than matters which make their way to the Planning and Environment Court. All right, well, that concludes my brief commentary for tonight. Now, I'll just see if there's any questions online. There doesn't appear to be. And while I'm waiting for anyone to come forward with any questions, can I just say thank you very much for your attendance. During this course, I've really enjoyed interacting with you, and all the best with your finalisation of the course, whether that's LAWS19038 or 11046. Any final questions? Yes, Spiros, do you have a question?
Not a question, mate, just a general comment. Thanks a lot for your input and assistance through the course. It's been great. I've really enjoyed it.
All right. Thank you very much. I really appreciate that. All right. Well, I might stop recording at this stage, and all the very best, and we'll keep in touch through Moodle. Bye for now.